Welcome to Prediction News Update. My name is Chris Gerlacher, the senior political analyst and industry analyst at Prediction News. We're here covering the prediction market industry, and we have a lot to cover today. I'm here with Daniel Wallach, sports betting appellate lawyer. Dan, how you doing?
I'm doing great. I didn't realize sports betting appellate lawyer was a practice area. I'm going to have to add that one to the website. I like it. Doing well. We definitely have a lot to talk about today. 6 things in particular.
Yeah,
there were 6.
There were 6 new amicus briefs filed in New Jersey, and they paint a really compelling picture of the opposition to sports contracts. So, Dan, let me go ahead and we'll start up by have what all this means, and then we'll get into 2 briefs in particular: the Indian Gaming Association and the American Gaming Association's briefs. But yeah, start us out by telling us what all 6 of these amicus briefs really mean for the case, because this case has made some strange bedfellows, I think.
Yeah, I mean, Kalshi got off to a very rapid start. Quick successes right out of the gate, securing preliminary injunctions in both Nevada and New Jersey, and those rulings were in relatively short order. By their very nature, when you move for a preliminary injunction, it's sort of an accelerated briefing schedule. There's not enough time for amicus curiae to weigh in. It's disadvantageous, I would think, to the states, because Kalshi, came armed to the hilt with their arguments that have been developed over the course of many months. New Jersey was on its heels, Nevada was on its heels, and I don't believe they made the full array of legal arguments. And it really did require the involvement of third-party stakeholders. In the case of New Jersey, the Casino Association of New Jersey, and Nevada, the Nevada Resort Association. And now you're seeing that brought to bear in the Third Circuit appeal, when you have entities and stakeholders that normally don't see eye to eye on everything. The Indian tribes, representing hundreds of tribes across the country. Not only did you have 60 tribes put their name on the dotted line, but there are also 9 tribal organizations, associations, whose members are comprised of hundreds of tribes. So you basically have the entire nation of Indian tribes represented in this one filing, alongside the American Gaming Association, which represents the U.S. casino industry. And then, of course, you have 34 out of 50 states signing on to a brief, blue states and red states. So it's as if it's Kalshi against the world, and all these various amici, which represent very significant interests, including groups that promote responsible and safe gambling. You have almost every voice in the room being heard on this brief. And why I think this is important is that now it's becoming more of an equilibrium has set in, where when the Third Circuit considers the merits of whether the Commodity Exchange Act has preempted state sports gambling laws, it's going to have a much fuller record, not just factually, but also a number of corollary arguments that didn't quite get presented in the New Jersey and the Nevada oral arguments. Now you have the specter of IGRA looming, because there's an important IGRA argument that the tribes are advancing, namely that these sports prediction contracts or sports event contracts, to the extent that they're available on Indian land, at least to that extent, they seemingly run roughshod over tribal exclusivity guaranteed under their federally approved compacts that are governed by federal law. So you have potentially a violation of federal law. And what do Nevada, Maryland, and New Jersey have in common? They don't have any tribes. So those arguments were not meaningfully advanced by states that are not tribal centric when it comes to the gaming environment. The tribes have brought a lot of weight to this, as well as 34 out of 50 states. And I believe the real analysis and the real decision making is going to begin with the Maryland case and the Third Circuit case. I wouldn't put too much stock in some of the early preliminary injunctions. Now we have all the issues being brought to bear and briefed by not only the litigants to this case, but by the amicus curiae, and it certainly is going to be a much more balanced analysis than what occurred right out of the gate.
Yeah, it was. I'm still fascinated that Stop Predatory Gambling has filed alongside the American Gaming Association. I mean, that is not, as a reporter in the gaming space for 4 or 5 years, that is not an alliance you'd ever expect to see.
but they want the same thing. They want the same
Right.
result. The American Gaming Association wants to protect their state licensed members
Mm.
whose product offerings that are licensed under state law face this dire competitive threat from prediction markets, and for different reasons. Stop Predatory Gambling and the Texas Alliance Against Gambling don't want this unregulated expansion of gambling because of the potential harm to the public interest through gambling addiction. I think they highlight a very, I mean, we laugh, okay, why is Stop Predatory Gambling filing an amicus brief? That might be one of the most important briefs that have been filed of all of them, because they highlight one of the key factors on a motion for a preliminary injunction. See, none of the other parties or amici focused on the preliminary injunction factors, and I keep coming back to the procedural posture of the case, that in order to get the extraordinary remedy of a preliminary injunction, I stumble over those words from time to time, you have to show four things, one of which is that it would be in the public interest to grant Kalshi a preliminary injunction. Here, Stop Predatory Gambling is saying, wait a second, there's a greater public interest in play here, which is the expansion of gambling, which destroys lives, the rate of suicide among gamblers being 15 times higher than the general population, increased bankruptcies, decreased savings. They highlight the harms, at least from their lens, the harms associated with gambling addiction as something that undergirds the public interest analysis on a preliminary injunction motion, not the public interest analysis that the CFTC does, which is a separate public interest analysis, although there's some overlap. To get the PI, you have to demonstrate that it's in the public interest to grant the injunction, and Stop Predatory Gambling is saying it would be against the public interest to allow for all this unregulated, unlicensed, guardrail-less, permissionless gambling that allows people 18 years and older to participate. Now, I'm not opining on the correctness of that, but they raise a very important counterweight to the arguments here that are advanced by Kalshi, and they focus on a completely different issue, which is the public harm, which is one of the elements of a preliminary injunction that none of the other amici tackle. And it's a really important point they make. Whether it carries weight with the court, who knows? But they add value by filing an amicus brief which focuses on that component instead of just simply echoing the main legal arguments advanced by New Jersey. That's one of the great values that can be added by an amicus brief to simply to discuss impacts and consequences that would be caused by the court ruling one way or the other. And Stop Predatory Gambling delivered, at least as to that point, they met their goal. They met the moment. And importantly, that's one of a tapestry of arguments that are raised by the various amicus briefs. And it does put pressure now on Kalshi to come back with its own group of supporters, which does raise the specter of where the CFTC comes into all this, because they're the 800-pound gorilla that I think the court is going to want to hear from, either voluntarily or involuntarily. And I think the momentum shifted when the Maryland Federal District Judge Adam Abelson raised a lot of questions during the oral argument about Kalshi's prior statements that were made in the election case, and ordered supplemental briefing directed to that issue, as well as anything else that the parties want to talk about. That was a turning point. But now the 6 amicus curiae briefs, led by some of the most influential stakeholders in the gambling industry, now shift the burden and place a burden on Kalshi to come back with support from the CFTC, because if the CFTC doesn't file here, that would be quite noticeable to the court.
Yeah. And I know we talked about the draft opinion, or the draft brief that Indian Gaming Association had earlier this week. But I mean, what's the significance of getting 60 tribes and 9 tribal organizations to sign on? Because that was, I mean, I just got back from Washington, from the Indian Gaming Conference and Expo up there, and there was a lot of happy surprise that there were 60 tribes and 9 organizations signed on. So What does that do to that brief and this case in
Well,
general?
they knocked the lights out on two issues, right? They advanced IGRA, which is their forte. I mean, you can't expect Maryland, New Jersey, and Nevada to carry the laboring aura on an issue with which that state attorney general's office rarely deals. So the tribal articulation of that argument carries with it a certain gravitas that it would be lacking if the states were doing that. And that's reflected in some of the state briefing on the IGRA issue. It's almost like a throwaway line. It's Wire Act, PASPA, and IGRA. Instead here, what the tribes are doing is they're the centerpiece of their legal argument is that how IGRA fits into this whole puzzle, where not only are the contracts themselves in violation of IGRA compacts because they're available for purchase and sale on Indian lands. You can buy or sell sports event contracts while you're in Indian territory, where those Indian lands may be subject to compacts that guarantee tribes exclusivity over gaming on Indian land. So there's that tension between that federally approved and guaranteed exclusivity and what Kalshi is doing. And that argument has not previously been articulated. And then with the tribes as a bonus, as an added bonus, I mean, you and I have been discussing the potential impact of the CFTC's non-enforcement or failure to enforce CFTC regulation or CFTC Rule 40.11A1, which is a categorical prohibition against all event contracts involving gaming, war, terrorism, assassination, and activities which are illegal under state or federal law. There's been some obfuscation or at least some disagreement in the earlier briefing as to whether that rule sets forth a blanket prohibition or, according to Kalshi, whether it simply gives the CFTC the opportunity to do a case-by-case public interest analysis every time a new contract comes in for submission under 40.11 subparagraph C. I mean, the language in the statute is plain enough. There is no, at least from the way I read the plain language of 40.11A and C, there is no case-by-case public interest analysis. The CFTC made that determination 14 years ago that all contracts that involve these enumerated categories are per se prohibited, and any case-by-case review is limited to determining whether those contracts themselves involve any of the enumerated categories, not to take the temperature on the public interest. But unfortunately, none of the three states were able to successfully articulate that argument in their preliminary injunction responses or supplemental briefing, and it was so maddening to me. And finally, the tribes come along and they bootstrap that argument onto the back of their IGRA argument, and they hit it out of the park. They made every argument. They brought in the external statements made by CFTC Acting Chairman Caroline Pham. They made reference to prior statements made by incoming CFTC Chairman Brian Quintanza, in which they acknowledged that that public interest determination had been made 15 years ago, and there's no further case-by-case or two-step analysis that's required. So that, I think, along with IGRA, is the most important characteristic of the Indian tribes' amici brief, that they finally, somebody made the argument in a way that is persuasive. Until then, until a couple of days ago, 5 or 6 briefs, nobody had successfully articulated, nobody had gone into the weeds, looked at the legislative history, looked at the rulemaking, looked at the out-of-court statements, and tied it all together. And Joe Webster, the drafter of the tribe's brief, just completely crushed that issue. So I think the two most important, they're all important, but I think the tribe's brief carries the most weight here.
And then before we wrap, I want to get into the American Gaming Association's brief a little bit. What arguments did they bring to the table?
Well, they the main thing was, and I think it was a theme touched upon by each one of the amici curiae, except for stop predatory gambling, and it's a theme that you and I have discussed previously on the podcast and at our conference at the SBC Summit in Fort Lauderdale, that when Congress speaks to the issue of sports gambling, it speaks loudly and it carries a big stick. It doesn't do anything silently or by implication. Hence, you have the Wire Act, you have PASPA, you have express declarations of congressional policy. And when it comes to sports gambling or gaming in general, there's absolutely nothing done by implication, through silence, through acquiescence. When Congress wants to legislate in the area of gambling, it knows how to say it, and it doesn't do so silently. And the AGA's brief touches upon a number of the legal doctrines, the major questions doctrine. You can't, it's like fitting an elephant into a mouse hole. I mean, all these themes that were the leadoff question at our SBC summit. It was the very first question out of the gate you asked me, which was, where does congressional authorization fit in to this whole equation when you have these express declarations of federal policy in the Wire Act, PASPA, and in several other federal statutes that expressly deal with the issue of sports gambling? And how do you square the CEE's delegation of exclusive jurisdiction over swaps to the CFTC as conferring anything near the same gravity of weight? And that was a theme. It was the first question you asked me. It was the first paragraph in my first Forbes article. It is the number one issue in the case. And the AGA and the states in particular added more heft to that argument. And yeah, I think the state of New Jersey carried the day in their opening brief, but hearing it in stereo from some of the most prominent firms, most prominent stakeholders, is not just the state AG's office. It's now the American Gaming Association, represented by the Covington law firm, one of the most venerable law firms in the United States. Mm-hmm. You're having significant law firms weigh in with their analysis. And when the judge is reading all of these briefs together, it paints a very compelling portrait on the issue of preemption. And it's one I think that may favor New Jersey and the other states, but it's important that these amicus curiae, or the amici curiae, don't sit on the sidelines, because to leave it all in the hands of like one party, I think you run the risk of leaving out some good stuff, some subtle points that maybe the New Jersey brief didn't make, that the AGA, the states, and the tribes made. So nothing was left on the cutting room floor, put it that way. And with the Third Circuit Court of Appeals having a panel of judges, each of whom is assigned 3 law clerks, you have a minimum of 12 jurists and young, brilliant lawyers who are going to be pouring through all the parties' briefs and all the amicus briefs. This is going to be a deep, deep dive taken by the court, and it will be done on the basis of fully fleshed out legal arguments, which was largely absent during the lower court proceeding, which by its nature was sort of a run and gun over in a couple of weeks type of legal proceeding, where there wasn't that same opportunity.
Mm-hmm. Yeah, it is going to be fascinating to see play out. Well, that's all we have time for today. So
I have one conspiracy theory. We have to talk about the timing on the state of New Jersey. I'm sorry, the timing on Kalshi. They asked for a 22-day extension.
They did.
And now it's all dawning on me as to the reason why Kalshi is seeking an almost 2-month period. They were seeking almost 2 full months to respond to New Jersey's brief. And the reason they did it, I'm convinced, is to give Brian Quintenz an opportunity to be confirmed as CFTC chairman, and then to empower the agency to retain outside counsel to file an amicus curiae brief. If they had to file by the original date of July 10th, I don't know if his confirmation vote has occurred yet, but until he's confirmed as CFTC chairman, maybe there isn't a willingness of the agency to take that position in court. Once he's confirmed, different story. So I think the extra time builds some runway for Brian Quintenz to hire outside counsel, and you'll hear the CFTC weighing in with a counter to all these arguments that are raised by the amici curiae litigants and by the state of New Jersey. That has to be the reason. And if the CFTC doesn't weigh in here, that does not bode very well for Kalshi's chances. They have to be heard. They absolutely have to be heard, and the court may in fact order it.
That's fascinating. I didn't even think of that. Well, we've got, Kalshi got their 14 days, so we'll see what happens.
The briefs are due on July 24th for Kalshi and July 31st with the CFTC. So Congress is going to have to hurry things up, but there'll be plenty of time for Brian Quintenz to hire some law firm of choice to draft a 20, 30-page brief as to why everything that everyone else said is wrong, and to focus on his view of the world. So he's going to get that opportunity, without which Kalshi's chances for succeeding at the Third Circuit are not going to be particularly strong unless they're backed up by the agency.
Gotcha. Well, that really is all we have time for this time. So if you like what you heard, like and subscribe, and I'm sure we'll be back in a few days to check in on some of these new legal developments. Dan, as always, thanks for being here.
Oh, my pleasure. Thanks for having me on. We always have so many interesting dynamics and dramatic turn of events to talk about. What an exciting space this is.
Absolutely. So that was Prediction News Update. Thanks again for Dan being here and for all of y'all for listening.